We got a big development in the military wife murder trial. Welcome back to Court TV Live. I'm Julie Grant. So this case is about a husband and a wife who got into a fight. It's no secret they had a toxic, abusive relationship. But what led up to the shooting? Did the defendant just momentarily go insane at the time? Did he snap? What happened? Well, the jury is the finder of fact here, but the jury hasn't been brought in. The judge was hearing any preliminary matters that need to be brought up, and guess what the defense attorney just brought up? He's making a motion for a mistrial. A mistrial. Why? Let's go in live together and find out.
Judge, if I could just say, many of these comments...
It doesn't matter, Mr. Eggert.
I don't enjoy being called a racist, and that's one of the reactions to this. I understand.
Mr. Eggert, I don't enjoy being called names too, but hey, I'm the one that decided to run for election and put the black robe on, so I take with it everything that comes with it. Nobody likes being called names. Unless you can identify that somebody that commented was a juror that called your name, it frankly doesn't matter.
Right, except I stand in my client's shoes, Judge, and this is generating...
And just for instance,
it's my client.
Okay. But that's not what your motion for the mistrial is.
Yes, it is. It says it's still up.
Well, but Mr. Eggert, your motion is not for a mistrial concerning pre-trial publicity or things of that nature.
Well, it's concerning the post that was supposed to be taken down.
Well, it wasn't supposed to be taken down.
Pardon me?
That's what I'm saying. Mr. Eggert, I'll listen to motions, but the motions have got to make a little bit of sense, and you can't just, throw everything against the wall. If you have a specific motion, I'll hear that, but you can't just grab at things that you don't put in your motions. And things that aren't relevant to the bias of a jury and things of that nature.
Well, Judge, I think this is highly relevant.
Well, and I'll listen to that, but you've got to tell me something specific and not you don't like being called a racist. Oh, okay, but whoop-de-doo.
Well, those were comments.
Okay, and if it wasn't comments from, sorry that you've been called a racist, Mr. Eggert. I don't think you're racist. I hope you're not. I hate being called names on Facebook. I'm not going to get into a diatribe about the downfall of Western civilization because of social media over us being called names because of the positions that we have. So let's move forward. If it has to do with that post, I will, as I did yesterday, voir dire the jury if they have not had any type of heard, seen, anything of that nature, then we'll move on, okay?
Well, Judge.
Anything else regarding that motion that's been denied?
Yes, I'd like to call Mr. Gillick to the stand.
I've already told you I'm not going to hear from Mr. Gillick.
Then I'd like to take place into the record, Judge, some of the comments in response.
I'm not going to hear any of the comments unless you can direct them for a jury. No, we're not going to have a further... No, Mr. Eggert.
I want a record of what was done.
No, unless you can identify those came from a juror, that's not relevant evidence to anything.
Further, Judge, would move, as we did yesterday, to call Detective Vance, because I believe it was Detective Vance who commented favorably or said he liked the post, and we would have was, and they said it wasn't.
Well, again, Mr. Eggert, I denied that yesterday.
Pardon?
I denied that yesterday.
Well, I'm moving again.
Okay. Well, then I'll deny it again today.
Well, Judge, I can put it as a group.
Mr. Eggert, it's denied. Let's go on. Let's start a trial today, and let's hear some evidence.
I agree, but I want these in the record. I would request these to be in the record.
Mr. Eggert, it doesn't matter what you want.
I agree, but I'm entitled to make a record of your statement.
No, you're not. Not unless I let it in.
Pardon?
No, you're not. Not unless I let it in.
Well, I get that, Judge.
And I've got to deem it relevant to the proceedings, and right now you've not proven it's relevant to the proceedings. Mr. Eggert, you might want to have a seat.
Pardon?
You might want to have a seat.
Then I'll take that.
Mr. Eggert, you might want to have a seat. Thank you, sir.
Exactly. Take a seat. Take a hint. My goodness. Let's talk about this. I've got C.K. Hoffler in the studio with me. Oh, C.K., you and I were just gripped by what we were watching here. Attorneys sometimes just don't know when to lock it up. But that's beside the point. Okay, the real point, the real heart of this matter is whether a juror made the statement right or saw the statement. Why are those things what's key here?
Well, I think they're key, but Julie, one thing that's critical that people have to understand is judges will tell the jurors, do not look at social media, do not look at television, do not Google on your phone to find out facts about the case. That's critically important. So the jurors are instructed not to do that. So what's critical in this case is, did a juror make that post? Did the juror see that post? If it's not related to the jury and to tampering with the jury or polluting the jury or doing something that would cause the defendant not to have his day in court, then it really isn't relevant. And I think the judge is trying to tell, he was trying to be very polite with defense counsel, but he finally just said, just sit down and be quiet and let's go forward. Because the defense made a motion but didn't connect the facts and the bias and any prejudice that the defendant would have to this racist post, alleged racist post. And I think that's the issue. And that's why the judge lost his patience and he said, sit down. He told him, he sort of gave him the legal roadmap. What's the relevance?
He said I get called things all the time, right?
Yeah. Right, that's just part of it.
So this defense attorney gets called a racist on Facebook, apparently. We haven't seen the post, so this is an alleged post out there, as CK said. And he moves for a mistrial on that basis. But like CK said, well, wait, well, why? So, I mean, people can say what they
whatever they want to say. And the state didn't do it. Like, say, if someone from the prosecution's office posted someone on Facebook, that's a completely different thing. Now, or if a witness that we're going to testify. So there's no connection at this point to the case, to the trial, and the defense cannot show any prejudice that is legitimately considered within the legal confines of the trial. So, because if we were to judge by that, Julie, there could be no trials. Because people, because people post all kinds of stuff on everything. So,
you're so right, CK. He's missing the link. There's no link. It's just, and it makes him kind of look like he's being a crybaby. Like, well, I got called this. Well, and the judge was nice. He said, I'm sorry that happened to you. I don't think that of you. You know, and just keep trying your case. Try your case. Stay focused here. Stay off social media.